welcome to a presentation by the Montana Human Rights Bureau on age discrimination. In order to understand age discrimination specifically, you must first understand what discrimination is generally. So what is unlawful discrimination? Unlawful discrimination can be simply defined as an adverse action taken in a protected area against an individual because of his or her protected class status. To help us better understand the definition of discrimination, we're going to break down and define some of its terms. This slide shows a list of the protected areas under discrimination laws that the Bureau enforces. They include employment, public accommodations, governmental services, housing, education, insurance, and financial transactions. Here you see all the protected classes under federal and state laws. Montana's protected classes are the same and overlap with the federal protected classes, but note that Montana law recognizes the additional protected classes of creed, marital and familial status, and political belief, whereas federal law does not. Also note that the protected class of political belief is only applicable in the areas of governmental services and government employment, and familial status only applies to housing discrimination. Age is a protected class under federal and state laws. The federal law that prohibits age discrimination in the area of employment is the Age Discrimination in Employment Act, or ADEA. Montana's Governmental Code of Fair Practices and the Montana Human Rights Act are the state laws that prohibit age discrimination in the various protected areas seen here. Under the federal law, the Age Discrimination in Employment Act, someone belongs to the protected class of age if he or she is 40 years old or older. However, under state law, someone is a member of the protected class of age at any age. Montana Code states that age means the number of years since birth. It does not mean level of maturity or ability to handle responsibility. These latter criteria may represent legitimate considerations as reasonable grounds for discrimination without reference to age. So now that you understand what is included under the protected class of age, we will next look at the type of age discrimination cases we see at the Bureau. Whether or not someone is a member of the protected class of age is a threshold issue, the first element, but not the only element, that must be satisfied when determining if age discrimination occurred. Age discrimination can take several different forms, including disparate treatment, harassment, by association, in an indirect way, retaliation when someone opposes age discrimination, and by print or circulation. We will now review each type of discrimination as it relates to the protected class of age. Disparate treatment cases allege that a respondent treated a charging party differently than others based on his or her protected class. The first step of an age disparate treatment case is the prima facie case. Prima facie is a Latin term that means on its first appearance. The charging party must prove each element of a prima facie case to show that what respondent did, the adverse act, looks like discrimination on its first appearance. The first element requires the charging party prove that he or she falls under the protected class of age. Next, the charging party must show that he or she was subjected to some type of bad act by respondent. And lastly, the charging party must prove that there is a connection between his or her membership in the protected class and the act taken by respondent. Some evidence that raises a reasonable inference includes that the adverse act doesn't happen to those who are not of a similar age, or comments that suggest age was a factor in respondent's action. When analyzing disparate treatment cases, a shifting burden analysis is used. As we just covered, in the first step of analysis, a charging party has the burden of proving the elements of a prima facie case. After the charging party meets that burden, the burden then shifts to the respondent to produce a legitimate, non-discriminatory reason for the adverse act it took against the charging party. Once the respondent produces that legitimate, non-discriminatory reason, the burden then shifts back to the charging party to prove that the reason proffered by respondent is pretext or unworthy of belief. In order to prevail on a disparate treatment complaint, a charging party must prove his or her case by a preponderance of the evidence. This means that discrimination more likely than not occurred. This standard is less onerous than beyond a reasonable doubt or based on clear and convincing evidence. Rather, it is a 51% probability based on the evidence at hand that discrimination occurred. It's important to note that the administrative rules of Montana change this analysis a bit in the event that there is direct evidence of discrimination. When there is direct evidence, there is no shifting burden. Instead, respondent must prove, by a preponderance of the evidence, that an unlawful motive played no role in the action it took against charging party. In the alternative, respondent can prove that the direct evidence is not credible or unworthy of belief. An example of direct evidence would be an annual performance evaluation giving an employee poor marks regarding his adaptation to a new software program, with the remark that the supervisor believes the employee's age makes it difficult for him to learn new technology. We will now walk through a case example so that you can see the shifting burden in action. A charging party filed an age disparate treatment case with the Bureau against her employer, a medical office where she worked as a part-time MRI technician. When she applied for the position that she currently occupied, she was interviewed via Skype and inadvertently heard the interview panel discussing their concerns that she would not be able to keep up with the workload since they assumed she was in her 60s based on her resume. A few years later, she applied for a full-time MRI tech position and was passed over for a younger candidate with less experience. Walking through the elements of the prima facie case, charging party was 71 years old when she filed her complaint and therefore was a member of the protected class of age, satisfying the first element. Respondent failed to hire her for a position she applied to and for which she was qualified, and so she was subjected to an adverse act, satisfying the second element. Furthermore, the hiring panel's previous comments about charging party being incapable of keeping up with the workload because they assumed she was in her 60s, coupled with their selection of a younger, less qualified individual for the position, raised a reasonable inference that charging party was passed over for the job based on her age, and she satisfied the third and final element of the prima facie case. When the burden shifted to respondent, it stated that charging party was not selected based on poor past performance reviews while she worked part-time. Then it was up to charging party to show respondent's reasons were not worthy of belief. First, evidence suggested that age bias continued during charging party's part-time employment, even after she caught the interview panel discussing her age. In essence, the employer scheduled the charging party in such a way to limit her assignments and then faulted her for only conducting certain types of MRI scans. Second, and most compelling, was that charging party completed a 13-week contract in Oklahoma when respondent stopped scheduling her, and she was offered a full-time position with that hospital after her stellar performance. With this evidence, charging party was able to overcome respondent's legitimate, non-discriminatory reason for failing to hire her. Ultimately, the evidence showed that respondent more likely than not passed over charging party for the full-time position because of her age. Harassing someone or creating a hostile work environment based on any protected class is unlawful, including age. The legal framework for a harassment complaint can vary based on what protected area the discrimination occurred in. As you can see here, the elements are different for harassment or hostile work environment complaints that occur in the area of employment versus harassment that happens in the area of public accommodation. As it relates to the protected class of age, generally speaking, a charging party must show that he or she is a member of the protected class of age who is subjected to either offensive or hostile conduct because of their age. Many times, the conduct comes in the form of comments or unwanted touching. After the charging party establishes that, the remainder of the elements left to prove depends on what protected area the discriminatory acts occurred in. Regarding the last element in the area of employment, how this is applied depends on who is engaged in the harassing behavior. For example, if the harassment is being carried out by a president or owner, the business respondent is always liable. However, if the harassment is carried out by a coworker or non-employee, the business respondent is only liable if it knew or had reason to know about the harassment and did not take prompt corrective action to stop the harassment. It is interesting to note that someone can also file a discrimination complaint for disparate treatment or harassment if they're treated differently because of their association with a person who is a member of the protected class of sex. This type of complaint is called a by association complaint. An example would be a bar refusing service to a 21-year-old because it disapproves of her being married to a 60-year-old man that has accompanied her. The bar is discriminating against the young woman because of her association with the older man. Retaliation is the second highest number of filings received by the Bureau each year. It's important to note that retaliation is its own creature, so to speak, rather than a subcategory of age discrimination. It is a bit indirectly related to age discrimination. Unlike most other forms of discrimination, the person being retaliated against does not have to be a member of a protected class or associated with a member of a protected class. Here you see the three elements that constitute a prima facie case of retaliation. Retaliation is when a respondent takes a significant adverse act against a person because he or she engaged in protected activity. Protected activities include opposing or objecting to discriminatory acts, participating in an investigation or case of discrimination, and requesting an accommodation. For example, if an employee complains to his or her boss that coworkers are mocking an older employee, the employee has opposed age discrimination and engaged in a protected activity. Likewise, if the employee acts as a witness in the employer's investigation into the age discrimination of the coworker, the employee has engaged in a protected activity. When determining whether or not the charging party was subjected to an adverse act, the question revolves around whether or not the act would dissuade a reasonable person from engaging in protected activity. Continuing on with the example just discussed, if the employer gives the employee who reported harassment and participated in the investigation into harassment a poor performance review or demotion because the employee engaged in a protected activity, the employer has retaliated against the employee. It is reasonable to think that a demotion or bad evaluation could dissuade the employee from speaking against age discrimination again. The state of Montana also prohibits any printed materials, advertisements, or applications used by employers that either state or imply that age, or any other protected class for that matter, is being limited or discriminated against in some fashion. For example, if an employer has an online application that asks as a preliminary screening question whether the applicant is 18 years old or older, and then rejects an applicant that answers no, that would be an application that expresses a limitation based on age. The only time employers are allowed to make such statements in print or applications is when there is a bona fide occupational qualification or BFOQ, meaning that an age restriction is reasonably necessary to the normal operation of business. But be aware, the laws that regulate whether or not a BFOQ exists make it a very high bar to prove the existence of a BFOQ. Under most circumstances, an employer will find it very difficult to establish it is entitled to such a defense. You should now have a basic understanding of discrimination laws regarding the protected class of age. Additional, more in-depth trainings on topics covered in this training, such as harassment and retaliation, can be found in other training videos offered on the Montana Human Rights Bureau's YouTube channel. For more information about discrimination or the Bureau, please visit our website at www.montanadiscrimination.com or call us toll-free at 1-800-542-0807 or locally at 406-444-2884.